Good morning, everyone, and this is the second and last part of our tort law or quasi-delict lesson. And before anything else, there are people, our subscribers and our Facebook followers and likers, asked why there's an advertisement on our videos on YouTube. Actually, we tried to troubleshoot it, and the team found out that it's by default that once the channel reach a maximum number of views per year, YouTube will have its, like, it has to have advertisements. Now, we cannot, since the team cannot buy a room or a, it's a tool to reduce or to remove the advertisements. So we are sorry that there are ads there, and actually the team or I am not earning out of that. So I just want to apologize and I want to explain why it's happening. Now, going to our lesson. Now, the topic for today again is about the basics of tort law in the Philippines. Now, as you can see, to give you a better example or understanding of this quasi-delict or in the Philippines, this principle, I'm giving you the statement in the slide, and if I may read this for those who are listening. Now, Juan was driving his car and hit Pedro, a pedestrian, resulting to several injuries on the latter's body. The injuries had to be treated for 3 days in the hospital, and he, referring to Pedro, had to rest for 7 days thereafter. So it means there are 10 days that Pedro was not in his usual life. Now, these are the observations that we can get from that example. It was Juan who caused physical injuries on Pedro. While he was driving his vehicle or car. Now, Pedro, the pedestrian, suffered from physical injuries because of the bumping or the hitting. Now, you have to take note of this very important observation that there was no pre-existing contractual relations between the two parties, Juan and Pedro. So, they have no contract. Party A and Party B are not related to each other, or they do not even know each other. And there is no legal relations between them. Now, based on these observations and this concrete example, you can have the following defenses, possible defenses of Juan. First, Pedro did not cross on the pedestrian lane, so he was jaywalking, so he was also at fault. Pedro was crossing when the light was already red. If you notice, especially in the cities, there are traffic lights even in the pedestrian lanes. So we have the green light for go, red for the stop, and orange for like getting ready or be wary. Now, another defense would be Juan tried to avoid a collision with a school bus. And when he swerved his car, he hit Pedro. Actually, this is an added possible situation, although from the original example, it's not included. Now, another last defense of Pedro would be, Juan rather. Pedro filed the case against Juan more than 4 years after the incident. You have to take note of these possible defenses because specifically, we will be discussing them right now. So what are the defenses according to law? Contributory negligence, that's number one. The contributory negligence must be caused by the complainant or the person being injured. So you cannot say that the injury was solely attributable or could be traced only to that person being complained of or the defendant. Now, assumption of risk. When Pedro crossed the pedestrian lane or did not cross the pedestrian lane, or if he crossed the pedestrian lane, the light was already the traffic light, was already red, then he assumed some risk. Like possible he could be hit, or a car passing by or like speeding up would be crossing. Okay, so now avoiding a greater danger or injury. That's the example when Juan tried to avoid a collision with a bus or school bus, because if a school bus, it means it has more lives there inside, like there are more passengers than one pedestrian. So as compared to one pedestrian and the passengers of a school bus, it is better for Juan to swerve his car and avoided the greater danger or injury that might happen. And now, prescription. This is what we call as like the complainant slept on his rights. And because our law does not allow a person like in perpetuity or in like during his lifetime, he could file the case. So there's what we call as a limitation. Like that's what we call as prescription. Within that prescribed period, the complainant must file the complaint or the case against the person who caused the injury. And under our laws, it is only within a period of 4 years from the happening of the event. So let's say it happened today, October 10, 2021. So Juan or Pedro must file the case on or before October 12, 2025. So that's what we call as prescription. Now, we go to the liability of a person based on the acts of or omissions of others. And this can be traced in from our Article 2180 of the new Civil Code. And there are 6 examples. So you have to take note of this. The father or the mother in case of death of the father or incapacity of the father over their minor children who live in their company. You have to take note of these 2, minor children and who live in their company. This should include incapacitated, meaning those who have legal incapacity or physical incapability. One example would be those considered as like autistic and who are considered as minor children under our laws. So they are under the company of their parents, and whatever acts or omissions that they've caused to another person, then the liability would be traced to the parents. Guardians, minors, or incapacitated who are under their authority and live in their company. So there are 3 now when it comes to guardians. And guardians should be considered as those declared by law. So those who are minors or incapacitated under the custody or authority of the guardians, there should be an authority over the minors and incapacitated persons by the guardians, and they should be living in their company, so not separated. And the third example of our 6 cases, owners and managers of an establishment or enterprise. When it comes to their employees in the service of the functions or in the service of the branches, and on the equation of their functions. So they are the employers or the owners and managers will not be liable if the act or omission happened outside of the function of the employee, like it happened already beyond the office hours or beyond the premises of the company, especially that they're not functioning their task. Okay, now that was our third, and fourth would be for employers on their employees and household helpers acting within the scope of their assigned task. So as you can see, for the third and the fourth example, employers should not be liable, or managers or owners of enterprises should of course not be liable if the employees went beyond their function. Okay, so Our fifth example, we're almost done. Our fifth example would be when the state is acting on its through a special agent, but you have to take note our constitutional law principle on like state immunity when it comes to example entry of a contract, or and another aspect of state immunity would be on the execution of judgments. But you have to remember at all times that the state is not liable when the public official or public employee is doing or performing an official function or task or within the scope of the authority, because that would be considered as an act of state. Last example would be teachers and heads of establishments of arts and trades when it comes to their pupils and students or apprentices. Sorry for the error there. When they remained in their custody. So teachers and heads of establishments of arts and trade, you have to be careful. But I fully remember my teacher back in law school, Attorney Dikdikan, when I cannot fully remember the Latin maxim, the singula singules. That's what I remember. And teachers should be read with pupils and students. Then heads of establishments of arts and trade should be read with apprentices. So this should be interpreted that way. And take note for those who are studying statutory constructions. And I remember now my students who are studying for their midterms. Okay, so again, we finished our lesson, and I hope that you learned something from our lesson today. And please look forward to next meeting, because we will be talking about cryptocurrency. Is that considered a legal tender in the Philippines? So we will allot a lesson for that. And again, we thank our growing numbers of likers and followers on our Facebook page, and our growing numbers of subscribers in our YouTube channel. And based on that picture, back then we had only 962 subscribers, and now the last time that I checked, it was more than 2,570. Thank you so much. And again, I explained earlier in this video about the ads. My apologies for that. I'm sorry if I cannot afford a room without advertisements. And again, our website, it is a constant work in progress, and I'm doing the SEO myself so that it will be more understandable for our users. Thank you so much, and the team will not be continuing without the continued support of our subscribers, likers, and followers. And please don't forget to share it to those people. And I know even those who are not studying law are watching our YouTube videos. Thank you so much, and please take care, because COVID is real, and actually I'm still suffering from the side effects. And yesterday I was that ill, and just now I'm recording before I sleep tonight. Thank you, and please take care.